Any mention?
May it please your Lordship?
Yes.
Lordship, I beg to mention item number 12. I pray that this matter may be listed along with WP Criminal 2 of 2023.
You're not.
Because both these writ petitions arise out of the same Lokayukta case, and we are challenging the proceedings before the Lokayukta.
So what do you want now?
Lordship, this matter may be listed along with WP Criminal 2 of 2023.
Why, these are connected matters.
Lordship, they are similar matters arising out of the same. We are challenging the Lokayukta proceedings, the same Lokayukta proceedings.
When those other matters are coming?
On 16th, Lordship. 16th.
Anyway, we'll just have it adjourned after 2 weeks.
Lordship, if it could be listed together because the issue involved.
No, the other matter, petitioner, the other matter.
The other matter is on 16th, my lord. I have spoken to the petitioner's counsel in that matter also.
It should be here. You see, we will unnecessarily will not tag together things. Sometimes it increases the problem.
Let it come separately, your Lordship, after 2 weeks. Just asking for adjournment, so let it come after 2 weeks. Then.
Yes. Look, that works. But just list this matter after 2 weeks. At the request of the petitioner, list this matter. We'll see it, madam, later. Just have this thing. Take your presence together one day and then we'll pass.
Lordship, then if this matter could be fixed on 16th August because that matter is coming on 16th.
This will come up on
15 of August.
after 2 weeks. That is yes.
Obliged, Lordship.
May it please your Lordship?
Yes.
Your Lordship, I crave your Lordship indulgence due to some personal engagement, your Lordship. I pray that item number 6, your Lordship, may be taken up next week on any date. I have informed the other side also, your Lordship.
No objection.
You're also there.
I'm for District Council, Lordship.
Okay. Item 6 after 1 week at the request of the petitioner.
Oblige, oblige.
Please, Lordship. Lordship, I beg to mention item 9 on behalf of the petitioner. Praying for 1 week time to obtain instructions, Lordship.
Who's the other side?
No objections, ma'am.
What instruction is needed here, Mr. Deb?
Lordship, after they filed the affidavit, this is a challenge to the advertisement, which was issued without a managing committee in place. So they've whether what has happened to that advertisement.
Yes, whether that post still
survives or not. 1 week time, Lordship.
No objections.
This also after a week at the request of the petitioner. Yes.
Obliged.
Please, your Lordship. Your Lordship, I beg to mention item number 8, your Lordship.
Item number?
Number 8, your Lordship.
Yes.
Your Lordship, in this matter, we are supposed to file written submission, your Lordship. So kindly grant us 2 weeks time, your Lordship. We'll file written submission, your Lordship.
That is that land execution
Yes,
matter,
Lordship.
isn't it?
Lordship.
Which should revive by again the government.
Lordship.
I pray for 2 weeks time, your Lordship.
You are willing to pay them something more.
Lordship will also file a
But the
submission.
parties are required to file written submission, your
Now,
Lordship.
are you willing to pay? Since
No,
it is your action which has reopened the case,
Lordship.
you are not inclined to pay. Where is Mr. Sen?
Lordship is on sanction leave due to some personal difficulty.
Okay, this 8 after 2 weeks at the request of the petitioner.
Much obliged.
Much obliged, Lordship.
Your Lordship, I beg to mention item number 14, Your Lordship. Your Lordship, in this matter, if you already incorporated the 2 copies in the paper book, Your Lordship, as per the last order.
You have prepared the paperwork.
Yes, Your Lordship. You've already inducted the 2 copies.
No, it's all right. Since once it is in the hearing list, I think that is already.
We need 2 weeks time, Your Lordship, since the.
Okay. 14 also after 2 weeks at the request of the appellant.
Obliged, Lordship.
Just at the request of the appellant, list is matter after 2 weeks.
May it please your Lordship? Your Lordship, I beg to mention item number 7. Your Lordship, we pray that we may be granted 3 weeks time for this, Your Lordship, for this matter, as we are still awaiting instructions, Your Lordship.
Instruction.
Your Lordship, in the last occasion, we were supposed to submit a list of interviewees. Dr. N. Muzika had
Oh, that is that
the trade
book matter.
test.
Yes. Yes. When do you want it?
3 weeks time, Your Lordship.
3 weeks, is it not too long?
Your Lordship, the department takes a little time to give us instructions.
But then it is not that you are asking time for the first time. You have taken time before.
Yes, Your Lordship, but we have not received any instructions, and
But
Dr.
that is okay, but
N. is
that-
on leave, Your Lordship.
If you have not received, then we will proceed without your instruction. Then we will have to decide without that. If department doesn't respond to your request, then what can we do?
Your Lordship, then just
2 weeks, not 3 weeks.
2 weeks, Your Lordship.
Yes, at the request meet on behalf of Dr. N. Majiga, under DSGA. Another 2 weeks is granted for obtaining necessary instruction in the matter. So,
All right. Let me, Lordship. Lordship, back to mention item number 10, Lordship.
yes,
In this matter, my lord, we're supposed to file the confirmation, service confirmation of the in respect to newly implemented party, response number 8. Since my lord, we are yet to receive the confirmation report from the post office. Madam, kindly grant me
why don't you
2
wait
weeks.
for the matter to come?
My lord.
It is, you are not asking me, see, let the matter come and then you make a mention.
All.
If it is with regard to filing of affidavit,
Yes, Lordship.
service affidavit,
Yes, Lordship.
and if you require further time, let wait for the matter to come.
Lordship.
Yes.
Item 11, my lord. This also we are supposed to file the affidavit. It's in the process of filing, my lord. We have served the
Affidavit
copy to
for?
the private respondent.
Affidavit?
Yes, my lord. This is, my lord, we are supposed to bring charge sheet on record, my lord.
So we'll then, okay, then we'll have it next week.
Kindly have it after 2 weeks, my lord.
Just item 11 at the request made by the parties, list this matter after 2 weeks. Meanwhile, you file it.
Yes, Lordship. Already served.
Do not take, you see, advantage of these 2 weeks.
No, my lord. Copy to the private respondent, we have already served it.
It's okay, but then it matters when you file it.
Yes, yes. No, it's yes. Already in the process.
Okay, just it will come after 2 weeks. In the meanwhile, you exchange things. Yes. Obliged.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 13, Your Lordship.
Yes.
Lordship, I pray this matter may be taken up after 2 weeks, Your Lordship.
You are
No, my lord, this matter was already heard at length, my lord. In the last occasion, your lordship asked for a certificate to the issue that whether the work was completed.
But, Your Lordship, it was the petitioner who has raised objection on last occasion also that the submission of CPW also matters, Your Lordship.
Your Lordship, submission of CPW will matter in this matter.
Definitely. We have only heard one side. That also you have not completed probably. Who is CPW?
Dr. N. Mozika, Your Lordship.
Let the matter come up, my lord.
If Dr. Majika is not here, then it will be again problem. And he was not well. He had undergone an operation. So that is what the problem is.
The issue remains, the fact that it was already heard, the CPW didn't have any instruction in the last occasion, and the only thing that your lordship was insisting that a completion certificate. The fact remains that we have been allowed to continue even after the filing of the FIR, in the supervision of the competent authorities. That is what was required by your lordship on the last occasion.
I pray 2 weeks, Your Lordship.
But you make sure then you take a plus. Tell him that this was a
Yes,
matter.
yes,
Probably on the other day also he was not present.
Yes,
here.
Your Lordship.
So it's hard by some length, and then he's appearing for respondent number
2 and 3, Your Lordship.
We'll have it after 2 weeks.
1 week then, because we have
If he
already.
is not well, if his again time is sought for, then will it help you?
No.
You see, you check out. You see, this is the problem is that you see, it should be between lawyers. Once you should interact, and once you say you are ready, then you just will have some understanding. You see, outside the courtroom. That is better. That helps the courtroom.
We have asked the other councillors, they had no. That's why.
Now, before you come here and all, before the things, if you just confirm to the other side if it's ready and all, otherwise, normally there is not much workload in this court. So, whenever you are ready, we can take up the matter. Okay, just say request has been made on behalf of Dr. N. Mojika, learned senior advocate, or DSGI.
Yes,
Appearing on behalf of respondent number so and so. adjourn the matter. On the ground. On the health ground. Though the petitioner has objected to the grant of to the prayer for adjournment, since you say although the counsel for the petitioner has objected to the prayer of adjournment, since the prayer for adjournment has been made on health ground, the matter stands adjourned to 2 weeks.
Deeply obliged, Your Lordship.
Supplementary cause list, item number 1.
My lord, this is the land acquisition matter where lordship has heard the matter to some extent regarding the expansion of the highway in Karo Hills, where earlier occasion I submitted that one petition is pending in the division bench regarding ROW, and consistently we informed the dishonorable court, and without opposition from my side, my friend's side also, matter was adjourned off and on. And later on, my lord, on 26th of last month, 28th of last month, they resisted that the matter pending in division bench has no connection. This petition should proceed.
That was insisted by the other side.
Yes, yes. So lordship was persuaded, and the hearing was started in the emission stage. And my lord, the hearing reached to a stage where we could point it out that the Section 11 notice was issued, preliminary notification was issued. Thereafter, within limitation time, we filed the objection, but the collector never addressed to that. And the issuer, Section 19 declaration. And immediately, less than 1 or 2 months, we approached this court, and this honorable court passed an order that we will not stay the land acquisition proceedings, but the collector is expected to maintain the records if he proceeds further. Thereafter, my lord, the NHITCL filed another application informing to this court that the land is not yet handed over by the collector because the petitioners and other landowners are resisting the handing over. In view of that, my lord, this honorable court also passed an order again that the collector is directed to facilitate the handing over of the land to the implementing agency, NHITCL. In the meantime...
But then that was not the subject matter of the case.
Yes, yes. In the meantime, collector was directed to afford an opportunity to the petitioner to present their case if he proceeds. Now, no notice was issued to the petitioners, and the matter reached for innovation hearing. And when lordship that issue came up about the violation of the Section 15, right to be heard, or disposal of the objection, the GA also conceded, as per the record, that yes, collector did not pass any order regarding the objections. In view of the lordship also expressed the mind that in that view of the matter, without going to the ROW and other issues, court can examine the legality. So I was pressing for quashing this, and in the meantime, my late friend pointed out that there was those 2 interim order, and the matter was proceeded. When the matter reached there, my friend representing the state sought time to identify how many land petitioners obtained the compensation. They say that many of them received the compensation. So lordship has given them time. I did not have objection. The matter was adjourned for the purpose of enabling him to prepare and obtain those
list of the person who have received.
Yes, who have received compensation. And now matter was listed again on 18th of July of this month. Now my friend other side sought time again. They inform us that the police don't oppose, we are taking time. So we did not oppose, and lordship has passed the order, adjourned the matter. Now surprisingly what happened now is, now when lordship has given time to them to prepare and take instruction, what collector has done? Collector has issued a eviction notice, vacation notice, dated 15th July. And to some of the petitioners, they have pasted that eviction notice, vacation notice on their door. And from yesterday onward, eviction drives started now. Even this 9:30 party informed me that petition number 81, JCP has reached to her place and taking started now. Therefore, yesterday I filed the application for staying that notice. And I also come across, day before yesterday, similar order was passed by the Court of number 2, staying the eviction notice. So the case fixed for the admission hearing, I'm ready for hearing. In the meantime, my lord, before I proceed on the merits of the case, main case, may I please with lordship permission the miss case, I file. Miss case number 136.
What is the miss case number 136?
136, it is on board, please.
This court, the court number 2 has passed some order.
Yes, interim order, stay order is there. I'll please that order.
Same matter.
Yes, madam. Same area, madam.
Yes.
Wait. Maybe. Learned GA is present here. Learned GA present. It's a very urgent matter. Lordship, may kindly see paragraph 5 of my application. paragraph 5.
Yes.
My Lord, with Lordship permission.
Yes.
The applicant came to know on 25th July 2024 that the copy of the notice dated 15 July was kept hanging on the front door of the applicant in his absence, even without similar copy of the notice also delivered in the same manner to some other petitioners. But most of the petitioners are yet to receive the same till date. Having seen the content of the same notice, the applicant and some petitioners could derive the meaning therein that the same was serving to them for vacating on or before 31st July, failing which appropriate steps will be taken against us. Thus, a foresaid action of the collector is nothing but an attempt to frustrate the pending writ petition or to ensure that the matter become fait accompli for the simple reason that while seeking adjournment on such for accommodation to ascertain the number of landowners who had received compensation for the land beyond ROW and simultaneously issuing the eviction notice behind the back of the writ petitioner, not to speak of this home court, which is highly illegal. The applicant also some other petitioner by such responded to the respondent collector who received the same on the same day, wherein they sincerely requested the collector not to take coercive action against them, since the entire matter has already been reached to a final consideration stage by this court at the same time, as the same has been fixed on such to the email. It is submitted the collector till they at no point of time issued appropriate notice or give opportunity to the applicant, the petitioner to present their case as directed by this honorable court. Therefore, the premises are still in the rightful position of the applicant and the petitioner till date. Hence, if the respondent collector is allowed to proceed with the said notice to forcibly evict, remove, and take over their land even without knowing the exact areas of land, structures, trees, crops at this stage, the applicant and other petitioner would seriously suffer, irreparably suffer, because admittedly, apart from this social impact assessment, no survey, no demarcation of land, no record, etc., has been as contemplated under the Act of 2013 is ever done and maintained by the collector till date. Merely offering compensation for the land beyond the ROW without adhering to the mandatory provision of law cannot validate the action of the respondent. May I just take my lord, page number 12.
Yes.
Is the last adjournment order. They saw time again. My lord,
12.
Page number 12, annexure 1. Since they informed us that
yes,
we did not oppose, so and lordship was graceful enough to give them time.
Yes.
And now my lord may come to page number 13.
Yes.
This is the first interim order passed on 7 August 2020. And the relevant portion may come to page number 15, my lord, in the last second paragraph.
Yes.
However, as there is a significant removal of trees and also some demolition of structures from the project site, it is expected that the respondents or the agency engaged in the project maintain record as to the specific areas from where the number and size of trees have been felled and removed, and also give records of the location of the perca structure which have been demolished in the course of widening the highway, which will be subject to further orders to be passed by this court. It's subject to, my lord. Last time that what they said is everything has been done. Subject. This was the order, my lord. They never come for survey, and there, my lord, may come to page number 16. Miss case was filed by the NHITCL, and order was passed in 2021. And my lord, may
what
come.
That miss case was filed?
Miss case was filed in 2021 itself. 21.
For
my lord, saying that the land was not handed over to the implementing agency, and therefore they filed this application for appropriate direction. And because of the lordship of this honorable court.
Now, if handing over, the court has, what is the direction?
My lord may come to page number 18.
Yes.
But may I start from 15, para 5.
Yes.
17. I have heard the learned counsel for the parties and given my thoughtful consideration to the matter. I have also seen the order dated such passed by this court, which has rejected the prayer of the petitioner who prayed for suspension of notification and further construction pending settlement of compensation. As the prayer for suspension at that point of time had already been rejected, the petitioner should abide with the order of this court and not to cause disturbance and allow the project to continue as the same is in public interest.
Yes.
Furthermore, as stated in the affidavit, the process of compensation is still not complete, and it is expected the petitioner be given a chance to be heard and present their case as and when they are called upon by the district collector. Misapplication is accordingly disposed of with the direction that district investigation within the shortest possible time shall facilitate the handing of the ROW to the NHITCL, and the petitioner shall not cause any obstruction. It is expected further that the records of the land as directed by this honorable court shall be made. The petitioner never obstructed. They never come for construction also. They never come for survey. My lord, and the order is very clear that if you,
but then it gives these things. That is the direction is basically for the state to hand over.
my lord, they have to.
It's a public project not to be.
My lord, they have to hand over. How they will hand over, my lord? They have to conduct the survey and demarcate the matter and hand over.
But then you see, like this court had also the court has also taken into consideration the order to 7/8/2020.
Yes, yes.
By which they rejected
suspension
the
of notification.
For suspension of notification.
Yes, yes.
So this is rejected.
My lord, suspension was of notification was rejected.
Yes.
Rejected. However, the Honorable Court deemed it fit that if you proceed further, you give the opportunity to the petitioners. Number one. Number two, petitioners should not obstruct. Yes. There was no complaint that we obstruct thereafter. That's not the case. Now the collector has to come.
See, this court's order, if you see this thing, this is made specific.
Yes.
It says that as the prayer for suspension at the point of time has already been rejected,
right,
the petitioner should abide by with the order of the court. It should not cause any disturbance.
Yes, yes.
And allow the project to continue.
Right, right, exactly.
That whatever is done is in furtherance of this.
My lord, that is true. Now, Section 11 was not stay. Section 19 was not stay. Now, what after that? What would happen? Collector has to come and identify the area, mark the area, and thereafter issue notice to the individual person.
You see which manner that is done. Now, this is the situation. Is that now what happened? That award has been prepared in this matter, isn't it?
No.
The award has not been.
No, not it. Therefore, my lord, I'm.
No, but then Section 6 is there.
My lord.
After Section 6, then
it is under the new act, but it is the same process. Now, my lord, after Section 6,
once Section 6 is there, they can take over position.
After Section 6, they can enter my plot under Section 8, identify my area, demarcate the area, and after 8, they have to issue me Section 9 notice. Lordship, earlier was other case with Lordship has.
That is that under the old act. You said this is proceeding under new act.
Yes, new act. Similar is section change of section only. Under Section 9, they will give a notice to us, and we will give a reply whatsoever. Then she will.
So far as the claim is concerned,
and she will pass, my lord.
See, Section 9 and all has nothing to do with the position and all.
My lord, yeah, I'm just explaining.
Section 8, 9. See, these are with regard to the identification.
No, my lord.
But then it has nothing to do with this thing, taking over position.
Lordship, if I may place my lord, the section after Section 9, then Section 11 they can pass a word, and after Section 11 passing the award, then they can they can publish the award to the individual recipients, and thereafter they can take over. That is the procedure.
So you want to say you can also say that before the acquisition proceeding is complete, no, they cannot take over the position.
My lord, therefore, my lord, they have to.
Is it
follow
your
the
submission?
Process. Lordship, can you see? My lord, if Lordship may refer. The negotiation. It is a very serious matter, my lord. Therefore, I'm impressing upon this court. Lordship is looking the new act or all act.
New act.
New act.
Once there is a specific judicial order,
my lord,
to proceed with the project,
my lord.
How can we pass some...
Section 11, I will not take my lordship time. And Section 15, lordship kindly say.
Wait, just a minute.
For hearing, we raised the objection. Our petitioner's objection is still pending. And Section 19, lordship kindly see.
Section 19 will be relevant here, is it?
Yes, but Section 19, declaration.
Yes.
So, my lord, this Section 11 and 19 declaration we sought for suspension. This Honorable Court refused to suspend it.
Just a minute.
At that point of time.
Just let us go through.
Well, Section 19, declaration.
Wait.
My lord. My lord, section 19 and section 20. After he issued that section 19, collector has a right to enter my plot. Section 20. Lord. The collector shall thereupon coast the land unless it has already been marked out under section 12 to be marked out and measured, and if no plan has been made thereof, a plan to be made of the same. So he can identify. And thereafter, my lord, section 21, notice to interested person. He will issue. And my lord may kindly see section 23. He can pass an award after compliance with section 20 and 21, which he failed to do.
In this case, the notification under section 19 has been issued.
Yes.
Therefore, the proceeding is up to?
My lord, after section 19 was issued, we came before this court. This order court refused to state this section 11, section 19. So allow the collector to proceed. Now he has to follow.
Section 9, so sorry, here section 19 has been done.
Yes, but immediately, my lord, within less than 2 months, I approached this court. But for the fitness of things, my lord, this order court did not state that those two notifications, 11 and 19, collector was allowed to proceed. And if he allowed to proceed, he has to, my lord, invoke section 20, my lord, section 21.
Section 20 is for marking of land. This is for the purpose of calculation of compensation.
To mark my land, my lord.
This has nothing to do with possession.
But nothing to do.
I'll come. At what stage?
Yes.
The authorities will have right to take over it.
I'll come to that, madam.
So far as the earlier writ of section 6.
Yes. Now I will show, my lord, I'll satisfy. Section 20, he can mark the nature of the land.
Yes.
Thereafter, my lord, after ascertaining the exact area, he will give a notice to us under section 21. I will not read through, my lord.
Section 21 is section 9.
Yes, section 9, earlier section 9.
That is for the purpose of claiming, putting your claim, yes.
Yes. That he did not do that one till date. And thereafter, my lord, section 23, the earlier section 11. Award, he can pass an award.
That is so far the preparation of the award is concerned.
Award.
Right now we are concerned with the question of possession.
Possession, I'll come to the possession, my lord. It is an inbuilt provision, my lord. The procedure is meticulously prepared under the area act. Now, after he passed the award, then under section 23, an award published. Thereafter, my lord, I'll come to Lordship may kindly see page the section 30 also, award on solution. Other section, my lord, I will not take, my lord, for when the negotiation lapse. The question of lapsing is not here. And possession will come, my lord, I'll come. Lordship may kindly come to, my lord, section 38. After he adhered to these procedures, fair procedures, collector has the power to take over. Lordship may kindly see section 38. For Lordship permission, may I read?
Power to take over proposition.
My lord, yes. The collector shall take possession of the land after ensuring that full payment of compensation as habilitation resettlement entitled are paid or tendered to the entitled persons within a period of 3 months for the compensation and for a period of 6 months for the monetary part of rehabilitation and settlement entitlement listed in the second schedule commencing from the date of the award under section sunset, provided the components of the rehabilitation settlement package in the second and third schedules that relate to infrastructural entitlement shall be provided within a period of 18 months from the date of this award. Provided further that in case of acquisition of land for irrigation or hydro project being a public purpose, rehabilitation and resettlement shall be completed within 6 months prior to the submergence of the lands acquired. The collector shall be responsible for ensuring that the rehabilitation and resettlement process is completed in all aspects before displacing the affected persons. I know rehabilitation issue is not submergence is not it is a highway expansion. Now the procedure is fairly provided. That collector, you go ahead. That is what the Disorder Court say. You adhere. You give them opportunity. And now when he complied with the my lord section 20, section 21 notice, he will give us a notice also. He did not do. Now all throughout he was keeping silent, and he pressed for early disposal, where Lordship has seized the matter for admission hearing, and on their prayer, Lordship has adjourned the matter. Now, my lord, what happened thereafter this? In the misscheme. Lordship, kindly come to my misapplication, page 19.
Yes.
My lord, this was a lengthy hearing that took place on 28/6. On that day, he started praying. Thereafter, my lord, notice, my lord, page 20. This is absolutely Lordship. Now, page 20, notice is 15 July, may I read, my lord?
Yes.
With respect to the matter of project such and such, the competent authority had declared its intention to acquire for widening of a 2-lane with geometric such and such in pursuance to High Court order such and such in 2021 in such 2022 21. It is hereby informed.
These are the orders which you have.
My lord.
Just now you pointed out.
Yes, which I have shown, my lord. In all concern, in the stretch of kilometers and such section, to vacate the land for authorities to proceed with requisite work. The construction work had been begun, and that in the remaining and incomplete stretches, such and such kilometer shall be initiated from 1st August. It is hereby notified to all landowners, structure owners, and any party in possession of the land for the aforementioned stretch to vacate such a land or structure by 31st July. Failing to do so shall require the authorities to proceed with appropriate action under law. It is hereby also notified to all landowners who are yet to receive compensation to claim the same from the Revenue Branch, DC Office, and Chura at the earliest after submission of the requisite document. Any person who willingly obstructs or goes unto hindrances in the efforts of administration to take up the land for completion of the said project shall attract strict penal action and legal liability under the 11th sunset. Therefore, the earlier order is very clear. The collector is allowed to facilitate the handing over in accordance with law. Writ petition should not obstruct it, and writ petition should be given opportunity. Now he quoted that judgment. Now he did not comply. He issued this. The next page 21. Therefore, immediately, my lord, some of the writ petitioner has given this reply. They reply immediately. Page number 21. They have submitted on 27. In the last portion, may
now this order, where does it say that you should be given an opportunity? This page 18.
My lord,
chance to be heard.
My lord, can you come to page number 18? 18 of that order quoted by.
That is okay. That is this. It says that the process of compensation. The process of
petitioner be given chance to be heard and present their case, as and when.
That is for process of compensation.
My lord.
The process of compensation.
This is for my lord entire land acquisition.
Now this if you say that you have to be given chance, that is for the purpose of process of preparation of compensation. It has nothing to do with handing over possession or taking over possession.
My lord, they cannot hand over, my lord, without that due process of law. The High Court never sanctioned the collector that you flout the entire procedure, take over and pay compensation.
But then in such a case, that RDR order could have been passed that way, saying that after the payment of compensation only the matter things.
No.
But it doesn't say so.
No.
This order,
yes,
dated 16/12/2021,
yes,
allows the taking over of land,
right,
and at the same time the process of compensation.
Yes, madam. How they take, my lord?
Then this order doesn't say that this thing, the handing over or taking over should take place after payment of completion of the payment of compensation.
But my lord, the taking over would be in accordance with law. That is very clear. This order of court.
See, so this order also in accordance with law, isn't it?
Exactly. And now,
this order, this reading of this order is very much clear.
Yes.
That the land acquired should be taken over.
Yes.
The petitioner should not cause any problem, and they should be heard in the process of computation of compensation. Yes. That is what. Nothing else.
My lord, how did the collector will take over?
The petitioner shall not cause any obstruction. Exactly. That is also provided.
Exactly. Now, how the collector will take over?
You are trying to interpret in that way that this petitioner should be heard even for taking possession.
My lord. No.
There appears to be something.
My lord, before taking possession, it is not required to give me. Section 21. Lordship, kindly see. Section 21, Lordship, earlier Section 9.
Just a minute.
Yes.
Wait a minute.
Lordship, kindly see Section 21 again. Subsection 4 of Section 21. Well, the same one, Lordship. The same with the Section 9. Well,
this miscases order plus in miscases are in this case.
In this writ petition itself.
In this writ petition.
Yes. My lord, may kindly take the pain to see subsection 4.
4 of?
Of Section 21 of the new 2013 Act.
Yes.
My lord, see. The collector shall also serve notice to the same effect on the occupier, if any, of such land, and all such persons known or believed to be interested person. He mentioned our name in the Section 11, Section 19. We're interested person. He did not give any notice.
Serve notice to same effect. Notice
Yes.
of what?
Notice for my lord objection.
Person interested. That is for the computation of compensation.
Lord.
This has nothing to do with regard to possession.
My lord, but
what this court is looking for is the authority of the government to take over the land at what stage.
Right.
That is the main thing.
Right. Like my lord, it is a journey to Guwahati. My lord, immediately I cannot land it in Guwahati without crossing Parapania.
It is not distinct.
In bill procedure is
in the
there.
act somewhere, Mr.
But in bill procedure
it is there. It is somewhere when it is rightful for the state to take over the land.
Take over, my lordship. Can you see that Section 38, which I read out?
We have seen that.
Yes.
We have seen that.
From that stage only, he is allowed to take over the possession and hand it over to any requiring parties. It is very clear.
Now, if you say about Section 34, then the order passed in the earlier miscase is not correct. Section 38.
Section 38.
Yes.
My lord.
Now, if you say that is mandatory, then which way this order of so and so? Then it means that the order passed earlier in the miscase is not in accordance with law.
But according to me, my lord, the moment this order could allow the collector to facilitate handing over of the possession.
What about see how do we see this miscase order passed in the miscase order dated 16 of 2021?
Yes.
In the light of the provision of Section 38.
Yes. Therefore,
how do we say it? What do we see? Now, which way? See, what is section? If you go by the provision Section 38, what you say?
Yes.
That taking possession is only possible after payment of compensation.
But that is the law provided.
But then, what about the interim order? That's
therefore, interim order never says that the collector should not adhere to the relevant provision of law. Collector can hand over.
No.
Now,
it
the
is
moment, my
not,
lord,
see, there 5 and 6 is clear enough, allowing the state to hand over the thing.
my lord, if we see the interim order properly, the moment he is allowed, he has to adhere to handing over. Petitioner should not obstruct. That is the meaning. But due respect, I believe that this honorable court would never allow the authorities to flout the rules, take over the position. That was never the intention of the interim order. The intention of this honorable court is to you hand over in accordance with law. Petitioner should not obstruct. You give them opportunity as per law. And my lord, we can see the order passed in the other case. One of the similarly situated person who is not the party here in the writ petition has filed a writ petition on 31st, and the order was passed. I should show, my lord. It is sometime, my lord. I will start from para 2.
Yes.
Well, para 3, may I start, sorry, para 3. It has been submitted by learned Senate counsel for the petitioner that the petitioner herein is in possession of meters running alongside the road, and the grievance is that without due process of law or proper acquisition process, notice has been served upon her. It has been further submitted that the petitioner has never been heard by the collector, though there are orders from this court directing that all concerned persons be heard before any action is taken for handing over a sunset. Oh, he was very clear. She further praised that as far as petitioner is concerned, the impugned notice became in abeyance. Mr. Sechi, appearing for the petitioner 1 to 3, has however submitted that due process has been carried out, inasmuch as declaration of section 918 has been issued, and further the subject matter is pending before the Learned Division Penalty Court. But I'm so sorry. They are the one who opposed here. Madam, I don't want to comment further. Madam, comment further. He is therefore submitted no. Madam,
very improper to happen.
My lord. It's a pain for me, my lord. He further submits that no interim order are called for this at this stage, and he may be allowed of the instruction. Having heard the counsel for parties and having examined the matters on record, as the matter concerned demolition and eviction, without entering into merits, it is provided that till the next date, the notice dated such issued by respondent number 3 as far as the plot of petitioner and is concerned.
This notice is stayed.
Stayed.
The same notice has been stayed.
Same notice.
So it is not protecting you, this order.
My lord, concerning the writ petitioner only.
Oh, okay, only this.
My lord. And here, my lord.
Yes, what do you say?
87 writ petitioners are here. Lordship, kindly state.
Your Lordship, in this case, there was minutes on 8/7/2024. So I just got this one instruction. Can I see it?
Could not follow. What did you say?
This is the one minutes of this DC office. And
no, what do you do with these things? See,
Your Lordship, after that this notice has been issued in 15 July. So they are saying, Your Lordship, that's they are not giving the option.
No, what about his contention that the land cannot be taken over until and unless compensation is paid?
So Your Lordship, here.
No, what is your contention with regard to that?
So Your Lordship, here there was no denial of the payment of compensation. First of all,
compensation has been paid. You want to say?
Your Lordship, there is no denial for payment of compensation.
What do you want to say that compensation has been paid?
Your
What
Lordship,
required for you to show that if the submission of the senior counsel is to be taken as correct, then you have to show that yes, you are proposing to take over the land after completion of payment of compensation. Now, what do you say?
So in this case, Your Lordship, as per my concern, we have deposited the amount to the Deputy Commissioner for payment of compensation.
So you do not know about the payment of. You see, you do not have to, Mr. Devnath.
So no,
you do not make indirect submission. See, it has to be.
No,
these are the matters of fact to be borne by the record.
No,
whether you have paid compensation or not paid compensation.
So Your Lordship, just 1 minute, Your Lordship. I am not saying whether the payment of compensation is paid or not. This is not the matters here. Whatsoever I am, my requirement is
the
here.
question is that what is the requirement of it?
So my requirement is here, Your Lordship.
Not your requirement. The court is asking what is the law.
So Your Lordship,
court is asking what is the law.
Your Lordship,
whether for taking over possession the payment of compensation is must or not.
So Your Lordship, that's why I am saying. For the moment, Your Lordship.
You are not replying.
Your Lordship, I am just coming on it on this point still. On my, we have Your Lordship, just I am just trying to inform to that court what is the status of this matter, Your Lordship, at the moment.
Just, this is a question of law. We are not. This is not a subject specific question. The question is that whether payment of compensation is must prior to taking over the land. Now you just tell us what is the law.
Your Lordship, for the moment, let us say this compensation to be.
Yes.
Your Lordship, in such event, if the petitioner not coming to take up the compensation, can the Deputy Commission pay the compensation, Your Lordship? And in the minutes also is given,
yes,
and time is given.
Just tell us one thing, please. State, you are appealing for the state. Yes, whether that this compensation has been paid. See, award is already there, William, isn't it? Award has been prepared in this matter. So who is there appearing in this for the state here? When will he be available? Can you wait till Monday, Mr. Sangaresho?
Lordship, kindly in the meantime, Lordship, stay the matter.
Your Lordship, for the moment.
Stay in notice.
For the moment.
Mr. Devnath, you are not replying to the query of the court, so it is. We are most concerned with these things. If you can show, if you say that this government has the right to take over the property after issuance of Section 19 notification, oh, it's okay. We are throwing out the case of.
Your Lordship, here in this case, in the writ petitioner, they themselves admitted there. More than 29 petitioner already having the compensation and stated
their name has been struck off, isn't it?
Yes.
So they are not a part of.
They are not the party.
Three of them struck off.
Another aspect of the matter.
3 petitioners struck off.
No, he says 29.
Other 27 of them filed an application for striking off with the liberty to file afresh with regard to ROW. The state resisted, and Lordship allowed me to withdraw that one. And thereafter they said together, they say that, my Lord, since their right with ROW remain the same, what the compensation offer is beyond the ROW. For ROW, they are not paying any compensation. And now the issue before this court is ROW. And this honorable court said they're handing over the ROW.
No, we are not going to say.
Exactly.
What the simple thing is that the person, those who have received compensation, is not a part of this petition.
No, some of them, 26 of them. Remaining 64, they are not yet receiving.
So that means that it cannot be like a clear case of that thing. So it means like those who have received compensation will have to hand over the part which has been acquired.
My Lord, they should hand over. Let them also show.
And
if they also fulfill the, my Lord, the procedure, definitely they have nothing to obstruct.
Your Lordship, another aspect of it is little bit I just interpret. In this notice, on 15 July, Your Lordship, it is clear here, Your Lordship, compensation has not been disbursed to all, because it is admitted position by the Deputy Commissioner. It is given. It is hereby also notified all landowners who are yet to receive the compensation to claim the same from the revenue branch of the district West Garfield at the earliest after submission of the requisite documents. It is given a 5 days. Whether they have given any documents to the Deputy Commissioner, or they claim, or they are not being paid. This is a big question, Your Lordship.
Yes, one thing is Mr. Sangaresho. If you say the question involved is this writ petition is with regard to the claim over ROW, then I think then you say like it has nothing to do with this taking over position. Even if they take over position, your claim for ROW will be subject to the outcome of the determination by the court. That will not prejudice your right.
No, my Lord.
Your Lordship, in this case,
is not going to prejudice your right. The only thing is that what Mr. Devnath is trying to say, that here you see, this award has been prepared, the compensation has been paid to some people, and those who have not received, they also can come and receive it anytime.
Well,
so that is what. So
that is, my Lord. If I
you say that some of the writ petitioners have received compensation. So then.
Your Lordship, even if you come paragraph 8 of this petition, Your Lordship, kindly paragraph 8 of the miscellaneous application, Your Lordship. May I read, Your Lordship, seeking for?
This application is filed by how many persons? Only one person.
My Lord, bring on record. So 87 petitioners are there in the writ petition.
No, but in here is applicant is only one.
Well, only one, my lord. Here, one applicant is bringing on record by way of filing this case for lordship notice.
No. Bringing on record means you have come with a fresh set of prayer. Then
for interim order, my lord.
No, it doesn't say. See, interim order is then interim order will be only with regard to this person, not others.
My lord, my lord is sitting in equity jurisdiction.
No,
It is not the case
tell us how many of you have received notice.
Notice.
Notice. The not many of you have received.
Well, I'll show in the miss case, I'll just show. Lordship may kindly come to my miss case.
We are with your miss case 136, isn't it?
Well, I'll show. My lord, can you see those recipient of the notice, 26 of them, and they have submitted the response to the collector.
No, see, this 22. Petition is, see, this notice has been served to whom?
Without even, my lord, the applicants, on the door of the applicant.
Mr. Sangresh, see, one of them cannot come with a fresh set of prayer. This prayer is not a part of the main writ petition.
That is,
so this is an additional prayer.
My lord,
even though it is a fresh cause of action. You see, we are not very sure that whether he could have come by miscase or not. Now, once you have chosen to come by miscase with a fresh thing, see, all should have been party. There is only one party. So, there is no question of staying it in respect of everyone.
My lordship can say by appointment on behalf of the others also. But by way of additional affidavits we could have bring, but lordship,
no, see, way of miscase. Averment is not enough. Here, fact remains that there is only one applicant, and this petition is only with regard to his case.
And notice is given.
It is not the case that, my lord, the applicant came here for the first time. Yes. It's a pending case, my lord. Therefore, we brought on record by filing this case by one applicant. My lord, lordship is sitting in equity jurisdiction. Without my application, lordship has enough power to take cognizance of the subsequent development.
That's a different aspect. We are here in a writ petition which has been filed, which has been registered. We cannot pass any order with regard in respect of everyone here. We'll pass only in respect of the person who has come here by this case.
My lord, the lordship is here to
Because of this person, he has received compensation.
No, nothing.
This Matthew and Sangma?
No.
Mr. Devnath?
We receive until I get
when Mr. Shen will be available? Yes, Mr. Gautam, you are also there?
I am there for only for respondent number 7.
Respondent.
You are not in this controversy.
I am not in this controversy.
Yes, madam. Yes. You want to say anything? We'll have it on Monday.
Well, lordship, till then the lordship may stay the order. They will continue to take the.
In respect of the applicant.
Lordship may be kind enough. It's a pending matter.
No, see, we cannot. You see, we cannot. Once we do it, then it will become. This is only one person.
It's a pending matter. If lordship permits me, all of them can file a fresh also, if lordship, but my lord, the end result will be the same.
All of them could have filed by one application, but then why there is only one applicant?
My lord, even if decide, my lord, they can file also, but that doesn't prevent them to move or to persuade my lord to intervene at this stage. Most of them are from villages, but the village.
Your Lordship, if I may have the matter come up on Monday. In the meantime, we'll also take our instructions because some of the petitions they have received compensation, Your Lordship. So we'll bring a list of all the petitions.
That is the same prayer, my lord. Lordship has given a month's time to bring that information.
It will be clear what's happening and then what's the submission given by the thing. Totally
unfair.
This is the one copy of the minors and member present.
The things has become unnecessarily complicated. See, like.
Let them maintain many minutes. Let him show when they issue notice to me.
And in this also given that if they are having.
This is a notice to you, isn't it?
My lord, the 15th July is notice to
me. That is what is impugned here.
Yes.
And prior to that, there is no notice to you.
No, nothing is such.
So minors also, there's petitioner has attended.
If they want to file a show cause, let them file show cause reply.
The time when this order was passed in 2021, there was no compensation paid to anyone.
And later on, my lord.
Later on, they have paid.
Later on, they pursued to some of the petitioners.
Now, after you according to you, if they have at all paid compensation thereafter, then there should have been further notice asking you to vacate. Is it your case or what?
No. My lord, here, after Section 19 was issued, they have to give me a notice under Section 21. Award notice should be given to me. They should come. They can come and collect the compensation. If they agree with the adequacy, they can go for.
So is it not
These
that
are different issue?
Is it not that it gives rise to fresh cause of fresh writ petition?
My lord, here it is.
Can all those things be raised in a miscase?
My lord, here with due respect, my
If
lord,
that is your case,
with due respect, my lord, this is the entire issue has ceased off, my lord, and these are the subsequent consequential action. My lord, seriously taken by the collector behind the back of this honorable court, I must say. They are here, they are taking time. And Lordship has given them time and they are trying to throw them out. And they are making submission in another court that the main issue is pending in the division bench. I don't want.
that is something very wrong to happen. That is something very wrong to happen.
Your Lordship, here they are all part of the same landowners, Your Lordship, and they're filing multiple cases on their own.
This writ petition, wherein that order dated 31/7 passed, is also a party here, no?
No, she's not a party. A new writ petitioner filed recently, single writ petitioner.
But then it is connection with the same accusation.
Same notice, same acquisition.
Same accusation.
Same acquisition. Submission of linear GA also reflected there. The Section 19 declaration was issued. And that is Section 19 we challenge here. It's the same acquisition process.
Your Lordship, if this matter may be taken up on Monday, Your Lordship will bring the instructions. Since this
But
other
let-
matter is also coming before court number 2 on
So then we will stay it till Monday. This is impugn order will remain straight till Monday.
Your Lordship, it can just be kept in abeyance for the time being.
Same thing. Keeping abeyance or staying till Monday will have the same meaning. Now the same contention has been raised in that petition also.
Yes, yes. They also that lady.
Non-adherence to the process of law.
Yes, that also she has filed the objection. It was never disposed of, never opportunity given, and that is her grievance. And suddenly,
As per our
notice was issued.
Objections have been heard, Your Lordship. Most of the landowners did not come to Your Lordship during the objections were being heard.
So you want to say that the notice was issued, whether they did not come up for hearing.
Not all of them came, Your Lordship. Just
Not all of them, but some of them they have come. Now, those who do not come even after receiving notice also, this will fulfill the requirement what is posed by the order of a law. Okay, so their mere absence will definitely not defeat the cause. Okay. Now, only thing is that whether they have been issued notice or not. You verify, you take instruction on that and let this thing remain suspended till Monday.
till Monday, Your Lordship.
My lord, I may pray. Let them file a show cause in writing.
We'll just see on
annexing
Monday
the,
what
annexing
happens.
the notices, my
Let
lord.
us see. But then,
Annexing
see,
the notices.
Mr. Sangresu, this
Well,
question
otherwise,
still
probably
remains
they
that
are
there
arguing
is,
the matter.
there is only one applicant in this. So we'll state only in respect of that.
My lord, I pray, I humbly pray, my lord, the entire petitions are here, my lord.
No, no,
So,
it can, but
the
then
one
what-
applicant brought.
So then this
brought notice.
application should have been filed on behalf of those things. This application doesn't even name them.
That is true, but my lord, here,
No,
the
see,
applicant
if you
is
say-
bringing
if
before
you
this
say
court
we
in the
cannot
made
go
petition.
beyond. We cannot go beyond what is this thing, what is pleaded and what is the part of record. How can we?
Kindly see my averment? It is very clear. It is on behalf of the entire petitioners here.
See how
In
can
this case.
then again that the question of this thing will come. Authorization will come. And at least you
My
have
lord,
to see in your writ petition names all the petitioners. Why it is only one petitioner?
But that is true.
So that is what the
also
problem
true.
is. We'll state only with regard to that person. It will remain this thing. So we cannot. You should have named them. If you want to say that this is a petition on behalf of everyone, you should have named them.
But naming is one factor, but averment is very clear since it is a pending matter.
But then you have not named them as the applicant here.
But the lordship is very much aware. Pending matters, one of the party may bring to the notice of this sort of court subsequent development. Point on behalf of everyone. Filing affidavit also same thing, my lord. So,
But then you are asking for consequential relief. It is not for the purpose of bringing on record something. It comes with a prayer.
That is true. That is true.
So,
that is true.
So, it's only it will be order will be passed only with regard to this person. Hard.
So, Your Lordship, in this case, then they send the petitioners, and he may be directed to submit the documents, whatsoever he having to claim the compensation to claim the compensation, because here main is the compensation to be paid to him. So he will submit the document to the deputy commissioner for the purpose of disbursing the compensation.
Question is not there. Then if the authorities are supposed to adhere to the provision of law, they should go by that. It is not for him and all. Once you prepare a word, once you award some compensation to him, then you have to inform him. That is what the law requires. So once you show it that you have informed him, and thereafter also he remains silent, then only you will have a case. Otherwise not.
My lord, I may pray for on Tuesday, my lord, when they had some difficulties. Other also coming up on Tuesday. Other new petition in court room number 2. Or Wednesday, my lord. Or Wednesday. Lordship, may I fix on Wednesday?
Hard, Mr. I just want to show. Not a senior counsel appearing for the applicant. And also MSS record rules. Will we have for the respondent for the one to 13. Mr. Gautam will be for
17.
then 14, no representation. Okay. You have not given a copy, supplied a copy to Mr. 14. Respondent number 14.
Respondent number?
Autonomous District Council.
But we have sub copy.
They may not be very this thing.
But their action also challenged.
We
have sub copy. We have sub copy.
So and so, acha. Then Mr. Devnath for
15 and 16.
15 and 16. And Mr. So and so for 17. After foots of non-APS for non-APS on behalf of respondent number 14. Stop. By this application, the applicant has sought the stay of operation of notice dated 15 July 2024. Issued by the Deputy Commissioner within bracket Revenue, West Garo Hills, Tura. Asking the petitioner, asking the applicant, not petitioner, applicant to page 20, isn't it? That is the notice. Is that page 20 of the application? Asking the people, and also asking the applicant, asking the people residing in the stretch of land from 85 kilometer to 95, 85th kilometer to 95th, 85th kilometer to 95 kilometer, and from 101 TH kilometer to 145th kilometer.
145.
Yes. Of the Tura Dalu road. Of NH 51,
yes.
Tura Dalu road, isn't it?
Yes, ma'am.
That is correct, Mr.
Yes, yes. Project in it.
To vacate such land or structure by 31/7/2024.
Thirty-first July.
By 31/7/2024. To facilitate the construction of widening of the road. Is that correct, Mr. Sangha?
Yes, yes. Well,
Stop. Mr. Paragraph, Mr. Sangresh, your honored senior counsel contends that the impugned order was issued in utter defiance of due process of law and also in violation of order dated 16/12/2021, passed in MC within bracket WPC number 88/2021, in WPC in this in WPC is not dated. WPC is this one, isn't it?
yes.
Are you
Yes,
dealing
same.
with WPC?
WCP number
This is an application filed in. This case is filed in which application?
My lord,
239.
239.
230. Acha. That's all right. Do not have to write in WPC. Okay. Only miss case number so 88/2021. It is also contended the petitioner has not been afforded any opportunity to be heard in spite of the fact that there is a specific direction to that effect by this court. Dear honored senior counsel, come on, therefore, praise that the impugned order may be stayed. So and so appearing for the state respondents 6 grant us some time on the ground that Mr. S and learned G appearing this matter is absent, and also for obtaining necessary instruction in the matter. Stop. Mr. Devnath, learned CGC submitted that the applicant. You say that he has been paid.
Your Lordship, this we have made payment to the Deputy Commissioner.
He says that the amount for the acquisition process has been transmitted to the collector for making payment of amount of compensation, and by this time all the claimants must have received their respective share of the compensation. Next paragraph. Since at this juncture the state has asked for grant of time for seeking necessary instruction, and there is nothing on record to show that the amount of compensation has been paid to the applicant, at this, it is therefore deemed appropriate at this juncture to suspend the operation of the impugned notice dated 31/7/7.
Your Lordship,
15 July.
Till
Your Lordship, here my one request, Your Lordship. Here, if you go for the entire.
Just a minute, let us complete. Till the returnable date. Stop. Yes, prayed for. Release this matter on, then give date on Wednesday. Yes.
Your Lordship, here, if this notice is stayed, and then for the purpose of this 85 to 95, and then 101 to 145 kilometers. So in these kilometers, so many people already they have obtained the compensation. So it will be stayed as a whole.
In respect of the applicant. She has to state in respect of the applicant.
My Lord, I may pray for the petitioners, my Lord. Lord, I profoundly pray. It's a pending matter, my Lord.
Your Lordship, if this order is clear, Your Lordship.
But then your writ petitioners also many have received compensation.
But only 26.
And this court is passing in thing only on the ground that there is nothing to show that there is the compensation has been paid.
My Lord, those applications also there, man. They will let them file also, my Lord.
Yeah?
Let them file a separate application. How many of them receive? If they are really interested, it is their duty to show that we issue notice to you. 10 of them notice have been issued, 10%, 5% come and collect it. It is a duty to show. But with regard to order, it is a pending matter. With due profound respect. If Lordship desire, they can file a separate application also. All of them.
They make it in respect of the writ petitioners. In respect.
Well,
that is what problem, Mr. Sangresh. I do not know what prevented you from naming these things. This is basically you should not have. See, unnecessary creation of unnecessary complication.
Till Wednesday, my Lord, let this remaining also let them file a separate application come up on Wednesday.
If you have done some mistake, then you should suffer for it. That is what the problem is. That way very much correct. There is only one applicant.
But it is a pending matter. No doubt I could have included all of them.
See, Mr. Sangresho, this petition is not only for the purpose of bringing some document on record. It comes with prayer. That is the main problem.
That is true.
No, it is only in respect of the applicant. Only in respect of the applicant. That is what it is.
In that case, Lordship, I may may come up, let them file a separate application Monday.
That is for your liberty. What you do it, you do not do it. It's up to you. But then just so far as this order is concerned, this will be possible.
But matter may fix on Monday.
If your officials committed some mistake, let them suffer.
My Lord, the collectors are on and on throughout. My Lord, they are flouting, playing around with this court. And my Lord, I pray I don't want to go further. Matter may come up on Monday. Let the remaining also file the applications.
But anyway, wherever you said this shall remain, what you said suspended till returnable date, isn't it? In respect of the applicant. In respect of the applicant. Okay? And then list this matter on such and such. That is what.
So it is
Is fixing on Monday. But
we'll be having it on Wednesday. That is what.
I prefer because on Monday, Tuesday they will finish. Well, they are taking even now also. Tomorrow they will finish.
So
I pray
Mr.
for.
Mr. Sangresh,
I pray for Monday.
See, if you want to file application in respect of others, that liberty will be there with you. It is not required for you to take it up. It is on your request. You are listing it on this day. Because this matter will be coming up in Tuesday before the other.
My lord, since I pray,
it is better since
Lordship is rejecting my prayer. Since Lordship is rejecting my prayer with regard to other petitioners.
We have not rejected anything. We have not said anything. We did not say anything.
Stay is not covered to the remaining petitioners.
That is
why, my lord. Otherwise, within 4 or 5 days, they will finish. My petition will come fighting
then with regard to such a case, you should have included their name in your application. What prevented that from including?
I consider they could have included, my lord.
Now, you see, their objection, it comes, they are very, very legitimate objection because your application is for only one person.
My lord, it is my lord.
If you see, this application has a prayer which is not a prayer of the petition.
My lord, it is for the entire, on behalf of the entire.
Yeah, just try to do things and then you don't know. You will have the liberty to file application on behalf of others.
But I only pray for Monday.
If it's up to you what you do. You do not do it.
Lordship, Monday, if Lordship permits. Madam may come up on Monday, my lord.
You said it on Wednesday.
My lord,
it is better that since other court also is dealing with these things.
My lord, since
so that is better to wait for the decision which is passed in this. We'll have it on Wednesday. We'll have it on Wednesday. You can file your application on Monday. That whatever application you file.
They will deploy the JCP and they will destroy the land and the forest.
Then you should have taken care of that while you prepare this application.
Since it's pending, they have only pray for Monday. Till Monday only.
Till Monday what?
Monday. Whether we come up on Monday.
No, see, if you want to file an application for others, you can file it. Who is this? Just because this matter is coming up on Wednesday.
Therefore, if the matter posted on Wednesday, and I file separate application and come up on Wednesday, by the time matter may come up,
we make a mention on Monday. We'll see. You make a mention on Monday.
They will have completely.
Make a mention on Monday. We'll see it. We will see to it. See, that is your thing. What prevented you from naming the others in the application?
But they are condemning to file the contempt also. Anyway, I'll make a mention on Monday.
If you prepare application, prepare it, file it on Monday. We'll take it up Monday. If type errors, you'll have it understood. Yes, make a mention. But then inform the other side before that.
Sure. Then again, this is my duty to inform.
You have done a mistake. You have to suffer for it.
Item number 2.
Nathan is there.
All right.
Item number 3.
Yes, what is this matter about?
It's a 482 petition, Your Lordship, for quashing the proceedings pending before the magistrate.
This is come up for hearing. This is the hearing column or?
Orders column, Lordship.
Orders column.
Matter is ready for hearing. So we'll list it for hearing then.
Lordship.
They're supposed to file some objection over last date.
Lordship, as per the
You are supposed
findings.
to some objection was there. You have taken opportunity for doing that. You have taken time for doing that.
Lordship.
So you
Lordship,
filed
as per the records, Lordship, there's no requirements to file objections. Lordship, we can take
No,
matters.
you see, on the last occasion you submitted that the instruction has been received by you.
Lordship, we received some status report.
And then there is no order to require them to file an objection. Is there any order? No order.
No, no, but they
Oh yes. Yes, Mr. Kumar.
Yes, sir. Now, like 18, Lordship kindly comes to 18th July report. 18th July. We have
18th July,
very
yeah.
program.
18th
Yes, sir.
7. What is 18th report?
But the report consists that we have not received any agreement, either by the opposite party or the
What is the
honorable
matter
district
about?
of
See,
court.
we do not, the court doesn't know the fact. What is the matter about? What is the matter about?
What is the matter for the quashing?
Your Lordship, I have filed the petition under 482 CRPC for quashing of proceedings pending before the Magistrate District Council Court. And
With regard to what offence? What is
the
the offence involved?
offence was,
The offences
was
are
registered in
section
2015.
What is the offence?
354, 354A, 323.
354 is molestation.
Molestation, Your Lordship. 354, 354A, 323 and 506
Yes.
IPC.
Yes.
And
then
here
what
the
happened?
highest...
One minute. Please hold on. Let us get this.
And here the extended punishment, maximum punishment is 5 years, Your Lordship.
No. The quashing has been sought on what ground?
Your Lordship, both the petitioner and complainant and accused
Mr. Kharwandang, the things which you have given, you want to take it back? Yes.
Much obliged, Lordship.
Lordship, in this matter, the notice is yet to, the service of report is yet to be served to the respondent number 3.
Lordship, actually in this matter, for respondent number 2, Lordship, we have filed a confirmation report from the postal department, Your Lordship, but we are yet to receive the report, Your Lordship, with regard to respondent number 2.
Now, is it supposed to file a service affidavit
Yes,
with respect to respondent number 3?
Or respondent number 3, Lordship, I apologize.
Respondent number 3.
Why you are saying 2?
Lordship, apologize.
1 and 2 is state, isn't it?
Your Lordship.
And then what happened? The service notice has been served.
Yes, Your Lordship.
What is the matter about?
It's about quashing, Lordship, of the proceeding, Your Lordship.
Please, Your Lordship. Lordship, in this matter, I pray for some accommodation. Your
Who is appearing for the petitioner?
My lord, me, my lord.
Your Lordship.
Yes.
Yes, my lord. I'm challenging the order dated 18/7/2023, my lord, passed by the learned trial court, my lord.
This is with regard to what?
By which this is regards to, my lord, quashing of the order dated 18/07/2023, my lord.
What is the subject matter?
By which my default bail, my lord, has been rejected by the learned trial court.
You are
The
still in
impugned
custody?
order is at page 18.
Are you still in custody?
Yes, my lord. Yes, yes.
This
Yes, my lord. I am still in
order
custody.
seems to have been passed quite some time back.
Yes, my lord. The order is at page 18, my lord.
You did not approach the trial court again.
My lord, the matter of approaching the trial court again does not arise, my lord. So I am here before your lordship to quash the.
When was it charge sheeted?
My lord, the matter was charge sheeted on date. My lord, after 18/07/2024, my lord, then the matter was charge sheeted, my lord.
No, when you charge sheeted? What is the date of charge sheet?
My lord, my lord, the matter was charge sheeted on.
Yes. What is your prayer?
Your Lordship, I pray for some accommodation.
My lord.
Where is the doctor? When do you want it?
Your Lordship, after 3 weeks.
3 weeks is too long. It's a bail matter, isn't it?
Then let it come after 2 weeks, Your Lordship.
My lord, my lord, my humble submission is that, my lord, the prayer here is very limited, and the issue here is also very limited, my lord.
We can
So
understand.
kindly.
The problem is with regard to the availability of Dr. Mojika. He is not well.
Yes, my lord. I have no objection regarding that, my lord. But my lord, if you kindly fix the shorter date.
We'll go after 2 weeks. Just say. But then.
My lord, after 1 week, my lord.
Not after 1 week again. This prayer is here. The prayer has been made for 3 weeks. We are giving them 2 weeks only. We are not giving them 3 weeks. Just say a request has been made on behalf of Dr. N. Mojika, non-SDSJ, to urgent the matter. by 2 weeks. Prayer allowed, list after 2 weeks. You just say prayer has been made without making.
Highly obliged, my lord.
Much obliged, Lordship.
Yes.
Hearing item number
Highly
2.
obliged, my lord.
What is the point of filing affidavit?
Yes. Service affidavit in respect of son of a
Yes, Lordship. Lordship, it seems that service has not been completed, my lord. It seems not delivered. So, my lord, may kindly allow us to take fresh steps, my lord.
This is service has not been affected. This has been returned.
Yes, Lordship.
Why? What is the reason?
What is the reason?
Is it insufficiency of the address?
Not delivered. And what is the reason given? No reason?
Okay.
My lord, probably it has not been received back. So, my lord, will have to confirm from the post office what was the reason for not delivering.
So, what shall we say that we'll take fresh steps, or can you do one thing?
My lord.
We'll pass an order allowing you to take fresh steps.
My lord.
And if you see that this return has been made because of insufficiency of address, then you verify the address and take steps.
My lord will do that.
Yes. Mr. Panthi, Learned Counsel for the petition submits that notice upon the respondent number 8 has been returned and served. Stop. We praise for allowing the petitioner to take fresh steps for service of notice upon the respondent number. For service of notice upon the said respondent. Stop. Prayer allowed. The petitioner shall take necessary steps for service within 3 days.
3 days, my lord.
List this matter after 2 weeks. This address is where? His station where?
Southwest Garrels. West Garrels, my lord.
2 weeks will be enough. Should be. It should be enough. Anyway,
It should be enough, my lord.
2 weeks. Yes.
Item number 15.
Obliged.
Yes.
Yes, Lordship. This is actually the petition which I filed it under 482 for questioning affair on the basis of actually what happened. Actually, this petitioner he has been convicted by the lower court below. So at the meantime, after the conviction, they have filed an appeal. The appeal is still pending. And then what happened is during the pendency of the appeal, the both victim and the accused person they have compromised. And then what happened actually? If that actually there is no.
That is what case regarding what? What is the allegation?
Regarding the allegation against that is that
under what section of law?
354, my lord. Just assaulting of women.
Molestation.
Punishment is 2 years only. But then I was at least convicted for one year, something like that, and 10,000 1,000 with fine. The appeal is actually they said that
was pending. Appeal against the.
Yes, that is what I heard, but they are, it seems that they have fixed for some.
Where is the appeal pending?
Before district session, just William Nagar. I'm yet to get that. They seems they have been fixed for.
We will not pass any order.
Lordship.
Even at all we find there is a compromise, we will not pass any order, because we would not like, if you have anything, you just go first place it before that court and then you approach.
I heard like the council informed me they have fixed for pronouncement of the judgment. I just still.
Once a matter stands seized by another court, this will not be proper for this court at this stage, and that also without knowing the outcome of the appeal.
I heard maybe next week or they will be pronouncing the judgment. I'm just waiting for that. Once I get in, I will bring.
You wait for that, and then
yes,
thereafter come approach. We'll have it after 2 weeks or 3 weeks.
Lordship, after 3 weeks, my lord.
Yes, Mr. Shulai. What is the position of law if any compromise is
Lordship, I have the
attained?
judgment. In fact, Lordship, I have given one. It's a very short
Oh, yes,
order,
yes, yes,
Lordship.
yes, yes, yes.
This is 354 after conviction. Some could say no. Kindly see, Your Lordship. The petitioner after full trial was convicted under section whether Lordship is the copy is there or not.
By which order? By which order he has been convicted? Order dated? Just tell us the date.
The
Date
order,
of order.
order dated, my lord, this
Conviction by the trial court.
by the trial court, that is on 21/07/2023.
21/07/2023.
Lordship.
And what is the date of compromise?
Date of compromise, my lord, it is recently, lordship, it is on
After
March 24.
Then you see that copy of order from Mr. Shula.
I have seen on the last lordship,
then-
on the last let them let the private respondent also have a say, because I think recently.
See, these they will not alter the position of law.
No, there is another judgment also, your lordship, where there is not only one judgment.
Then you show us some Supreme Court
Yes,
decision.
I sure, because at the time of hearing, man.
Why you are so impatient? You just
Sorry,
show
Lordship.
some decision of the Supreme Court countering this decision.
Definitely,
Why-
definitely, my lord. I assure, my lord.
You just say at the request of the petitioner list after 2 weeks.
Lordship. After 3 weeks, my lord, because let the order also, because at the meantime they may pronounce the judgment, and
There is no
Lordship,
interim order.
only one thing is done.
Yes.
There is no statement whether he is in custody or whether he was
no, he was.
bail-
I stated at the time I was not in custody. It is there.
whether bail has been granted to him by the
I was not in the custody.
trial court or not.
Anyway,
I'm making a statement. He was not in the
this is,
custody
see,
at the
normally
time when
if
I
it
was
is 1
filed.
year's conviction and all, it is expected the trial will be. You see, there's normally the sentence is suspended. That is what the proposition.
by
But even
operation
then,
of
I do not know whether these things. We'll see it, all those things on the next day when
Lordship.
after 3 weeks.
Lordship.
Apply, Lord.
Most blessed, Lordship.
Thank you.